Our first speaker of the day is Curtis Karnow, and it's kind of good to see him. I was first introduced to Curtis over 10 years ago when he spoke at the very first DEF CON in Las Vegas in front of a crowd, couldn't have been more than 100 people, 80 people or so. And I thought it was really neat because here I was, this little kid, and this big, hotshot attorney guy wanted to speak at my convention about was it intelligence? No, the problems with virtual learning on VR systems. And if there's a problem in, say, the virtual learning software, and you train a whole group of people to do something incorrectly, and then under stress they do the wrong thing, who's to blame? And I thought that was really cool. And then he followed it up with a great intelligence agents liability talk like a year or two later. And it's been 8 years and we still don't have virtual agents. So he's a little bit ahead of his time sometimes. So I'd like to introduce Curtis to you all, and with that, thanks for making it back for the first talk. Curtis?
It is neat to be back. It's true that some of the VR stuff and agents issues that I talked about in the past are not quite here. The issues we're going to talk about today, the technology is very much here. It's technology that you use every day. But the law has not only not caught up, but we've gone back approximately 900 years to reach for analogies to talk about the legal issues that are raised here. The essays, I am indebted greatly to Jeff because he got me started on a series of writing essays and thinking about issues in technology and the law, all of which are collected in a book available outside. So help yourself. I'm going to make sure that we have questions. Enough time for questions at the end, which will probably be the best way to handle questions. What I'm going to be talking about today, focusing on automated intrusions, not individual intrusions which are executed one by one by a human being with a specific target. Those are less interesting legally. They're more black and white as to what the law is on that kind of stuff. But I'm going to be talking more about automated intrusions. As I said, we're reaching back about 900 years, back to ancient doctrines like Trespass and Nuisance, stuff which really goes back to the 13th century, the 12th century in England, to try and get images, analogies, and metaphors to help judges and lawyers understand and to talk about the sorts of problems that we have today. It will not shock you when you find out at the end of this talk that a lot of that stuff does not work very well, and it produces a lot of really counterintuitive results as to what's legal, what's not, and what the line is between things that are legal and not legal. So I'm going to start off talking about sort of the legality of intrusions to begin with, and I'll be spending most of my time there because that's the backdrop for something which is even more interesting, I think, and which is the legality of Counterstrike. As a lot of you know, Tim Mullen is with us here. He's been at BlackHat before. He's going to be presenting around 4 o'clock this afternoon, talking about a product called Enforcer, and has written a number of columns which have generated a lot of dispute and argument about the propriety and legality, the wisdom of striking back on your own to a perceived attack. And the legal issues there have really caught my attention, and so I'll be finishing up by talking about that. The sort of the self-defense, self-help theories actually have come up, like a lot of these things in a culture, they all have suddenly come up within the last year in 3 or 4 different sorts of contexts. We've got the Berman bill, which is floating in Congress, some of you may know about, in which the recording content industries are seeking legal authority to, in effect, strike back at P2P networks and to strike back at files that ought not to be shared on those networks. They want to have a legal authority to go in and just and burn that stuff up on their own without any law enforcement assistance. We also have a statute which had been making a circuit around the country called UCITA. Different states have been thinking about implementing this. Virginia and Maryland already have, which may authorize licensors to kind of reach out and turn off software which they believe is being used in contravention of the license agreement. So we've got a number of places like this where people are talking about this stuff. And then, of course, the classic strike back, where you go back after an attacker and turn off that process or shut that system down that's attacking your system. The thin gray line is something I'll come back to at the end. What I mean by the thin gray line is that the kinds of ideas that the law uses to distinguish between what's okay and what is not okay very often are impossible to implement in the technology that we're talking about. And we're going to find out that things that you thought were legal, like port scans, even the most basic sort of port scans, technically are probably not. And things that we have thought perhaps are clearly illegal, like Counterstrike, a good argument can be made that those things are legal. Very often, these things are going to depend on very, very small differences of fact, which is very bothersome to people who are trying to conduct themselves lawfully and don't know which side of a line which side of a really chaotic line they're going to fall on. It can depend on, for example, whether a spider is being issued by a search company or a spider has been issued by a competitor or some company which is not a search company. Those small differences in who is launching the spider, small differences in the amount of pings that go out within a certain period of time can be really very important. I'm going to be focusing on automated systems for reasons which I've already alluded to. The automated system is one in which no human intervention, no human intent intervenes to target the system. And the problem, of course, is that that's exactly what the law focuses on. The law tries to distinguish between a mistake where you didn't intend to do something wrong and something you intended to do and then it occurred. But this human intention doesn't exist in an automated attack and an automated counterstrike. So that really presents part of the problem. So again, 3 parts to what I'm going to talk about. I'm going to talk about the basic laws, civil and criminal liability. I've handled both of these. I was a federal prosecutor for a while, and currently on the civil side handle some of these issues on both sides of the gray line. I'll talk about what an intrusion is and what this key notion of authorized means, which really underlies almost everything, all of the laws that apply in this area, and then on to Counterstrike. So basically, basic laws on intrusions. These are very, very, very broad. To get a visceral grip as to how broad the laws are, understand that the federal government has a whole series of these things. Understand that the state governments, almost every single state, has a whole parallel set of enforcement mechanisms and laws as well. And everybody wants to get in on the act. Everybody wants to be the hotshot prosecutor and come in and make a case and get some sort of nice high-tech something or other underneath his or her belt. I've defended a number of cases in which there was really, when you looked at the facts, it was very boring, it was uninteresting, it was just maybe at most some kind of a vandalism where in fact no crime at all had occurred. But the prosecutors latched onto very, very broad statutes that were written by completely paranoid people who did not understand the technology at all, used that to go after some folks. And it can be very, very troublesome. So the basic idea behind, for example, the Federal Computer Fraud and Abuse Act, which is our Bible statute, is that of an authorized or permitted access to a computer system. So if you are not authorized, you don't have permission to access a system or a file or a drive or any other way that you want to break a system up or even communicate with a system, you're in violation of federal law. Let me just drop a footnote here. I don't know if anybody's had a look at the U.S. Patriot Act. Probably some of you have. There are new definitions of terrorism and new penalties for terrorism. Terrorism includes this now, and the penalties are up to 20 years incarceration. There are even more stringent laws that are being contemplated in what I call son of U.S. Patriot Act, which is currently being floated around in the Department of Justice. So that's the basic concept, is permission and authority to access a computer system. We've also got this notion of a kind of a counterfeit access device. If you're even in possession of a counterfeit access device, that's a federal felony. What is an access device? It's everything. It's everything under the sun. It's any kind of code, number, or machinery that can be used to obtain anything of value. So it can be a password. It can be this cable. It can be anything at all that allows you to obtain something of value to which you are not entitled. Any kind of use of any computer resources under most state laws is a state crime. So just using up CPUs, just using up a little bit of memory is the use of a system resource, and unless you are authorized to do it, it's a violation of that state's laws. In California, for example, illegal access, this is an important definition. I hate legal words, but I'm just going to read this one out because it's really, I just want to get you a feel for how broad this stuff is. Unauthorized access. Access means to gain entry to, instruct, communicate. We'll come back to that in the context of port scans. Communicate with the logical, arithmetical, or memory function resources of a computer, computer system, or network. Probably includes port scans. So it's extremely broad. That means anything you do is illegal. It all depends on one underlying fundamental concept, which is, are you authorized to do this? Which is why I'm going to be focusing on that idea in a second. Civil law. Civil law, that is to say, the government's not in the case. I sue you directly. I sue your company. I want money. I want a court order to stop you from doing what you're doing. Civil litigation. Well, the Computer Fraud and Abuse Act also can be used in a civil litigation context. Then there's trespass. We'll get back to this in a second. Trespass, how do I begin with trespass? But just briefly, trespass is incredibly rapidly developing area of the law now in this context. But about 800-900 years ago, it was interfering with somebody else's possession of their land. So you put your finger on somebody else's fence, or you blow smoke across somebody else's fence, or you touch the heifer that is on somebody else's, just on the other side of somebody else's fence. And that's trespass. The actual word, if you remember the Lord's Prayer, forgive us our trespasses, you'll realize that trespass really means a wrong. Just means it's a wrong, some kind of a wrong. So it begs the issue completely as to what a trespass is. You cannot tell from history what a trespass is, but it's being used today in an almost limitless way to punish, in a civil context, anybody who uses another computer system without authority. The other, the issue of authority to do something with somebody else's computer system, where do you find this authority? It's in TOS's terms of service, and we'll have a couple of samples. Everybody's here probably not read all the terms of service that apply to all the billions of sites that you visit every day, which itself is an interesting issue. But a terms of service will give you authority to do stuff on that site and limit your authority to do stuff. And of course, robot exclusion standards, which have been around for a long time in the industry, but only now are we getting 1 or 2 court opinions that recognize that that may be the place to go to try and figure out whether or not some kind of a bot has a legitimate reason to do what it's doing on the site. Trouble is, a lot of sites don't have any kind of robot exclusion standards at all on their site. So what does that mean to a spider that doesn't read English? We'll get back to that in a second. So I'm going to discuss a couple of the, in a few minutes I'll talk about some of the classic cases that have now come up in this trespass area. But you can sue somebody for trespass and get them to stop doing what they're doing and get money from them for them having done it. So the core places where you get the sort of authority to do what you're doing, both for civil and criminal liability. You know, at this point, we're not going to distinguish the two anymore because the underlying issues are really exactly the same. Authority or permission can be express or it can be implied. I mean, express permission is when I say, go ahead, come onto my site, take a look around. And the terms of service are that sort of express authority. And those aren't interesting. That's easy stuff. It's not worth talking about anymore. The real issue is, when is there an implied authority to come onto a site to do something or to do something with respect to somebody else's site? Suppose there are no restrictions at all on the site. You know, what is permitted on that site? There are basically these 3 kinds of restrictions. The robot exclusion standards I've talked about. There's authentication technology. So if you just have to give a password and you somehow get around that, I think most people will agree that you didn't have permission to do what you were doing. The trouble is that there are so many different kinds of permission that are maybe available. And the real problem when we get to the automated intrusion context is that all these different sites have different rules at every single site. You will not find the same terms of service. You will not find the same wording. You will not find the same kinds of permission at these sites. And in the context of where you're launching a single spider or a single, we'll call it intrusion for now, you will have different, it'll be permitted and not permitted in different ways at different sites. So let's have a look at, classic terms of service. It's not even worth, I'm not going to read this out. You've all probably seen this stuff before. This one may be from eBay. There's a classic one at Amazon. Over the last year or two, they've started throwing in the robot spider stuff, automated devices, and all this stuff is in here. Of course, it's in English. It's in English, which means you won't read it because you don't care. Nobody reads this stuff anyhow. But number two, the spiders and the automated intrusion devices, of course, are not going to read this stuff either. So it's really questionable as to how effective these things are. Now, with respect to, let's see. There are a couple of new cases that I wanted to talk about. This is really, at this point, you really start getting a feeling for what's happening in the courts, what sort of cases are, what sort of cases out there, and what judges are doing. The background here, of course, is that you have a judge deciding these cases under the following sort of circumstances. The judge has only barely figured out how to use a cell phone. So that's the person you're talking to now. They've just figured out the cell phone stuff, how to pick up a message on a cell phone. Everything is under a very expedited situation. These sorts of cases, things tend to happen. Usually the first motion for preliminary injunction, temporary restraining order, happens usually within about a week, maybe a month or two. But everything is very accelerated. It's very fast. You've got a lot of experts coming in and blathering at the judge, who by and large doesn't understand any of this kind of stuff at all. This is not where the judge has come from. This is not his or her experience. But this is the person who's deciding whether something has happened. And we've had some very bizarre cases that have come out. We have, for example, bots retrieving meta tag information. You can call it screen scraping if you want. And just going off and picking a few things up and bringing it back home. Very, very routine stuff. Well, in the Oyster case, that was illegal. And people said, and it was illegal under this trespass theory. The idea was that the bot was trespassing on the system, and it was injuring the system by overloading the system in some fashion. The point was made that the interference with the system was negligible. You could barely notice it. It made no difference to the system whatsoever. The argument was made that if you go back 800 years, you will find out that trespass actually had to be sort of substantial. When I told you put a finger on a fence, I lied. The cases actually don't come out that way. It has to be something there before a court will step in and intervene. The judge in Oyster said, I really don't care. I don't understand this kind of stuff. I don't know how much load was put on the system. I don't know how many CPUs were occupied. It doesn't matter. You can't do it. They said you couldn't come to their site. The terms of service said you weren't supposed to do this, so you can't do it. The bot may not go in and take off that meta tag information. We've had more exaggerated cases, and unfortunately some of the law was made in a case called eBay versus Bidder's Edge, where it was really, there was a pretty good example of perhaps more stress on the target system. About 100,000 times a day for many, many months, Bidder's Edge was picking up all the information off of eBay, putting it on their site, and inviting you to come to their site to track how your auction was going and selling the advertising to you. eBay was really unhappy with this. And unfortunately, this is a case where a lot of this law got made. And here we had a much more sort of substantial situation. The wording used by the judge, however, was any interference at all, any kind of use of a bot on the system which is not authorized is a violation of trespass and the Computer Fraud and Abuse Act. There was another case called Vario and Register.com. Vario used bots to get the Whois database off of Register.com. At the time, there was no term of service at Register.com that said you couldn't do this, nothing. So the judge said, well, as to everything that's happened up to now, nothing I can do about it because you didn't say that they couldn't do it. You didn't say it in a terms of service that they couldn't do this. But now, Vario, you know that you're not supposed to do this. They've sent you a note not to do it, so you know you're not authorized. So from here on after, I'm enjoining you and issuing an order. So screen scrapers have been held to violate and exceed authorized access under the Computer Fraud and Abuse Act. And the cases are now moving up from the district courts or the trial courts up to the courts of appeal. And the problem when judges at the Court of Appeal, which is right below the Supreme Court, start talking like this and start saying, anything that is in excess of terms of service or something like that is an unauthorized access, that starts getting nationwide attention and everybody starts citing to it, and the law is starting to get frozen at that level a little bit. And what's happening is the worst possible way to make law. These are civil cases. Nobody's going to jail in these cases. But they're relying on the Computer Fraud and Abuse Act And they're saying that this kind of an action is a violation of that, which is a criminal statute. So the law is starting to get frozen into place that this kind of stuff is a violation of criminal law. Cookies transmitted without authority, computer fraud and abuse violation. The Intel case, very interesting case, don't really have time to go into it today, but this was spam going into Intel's proprietary email network. Intel made claims both under Trespass and Nuisance, and said that they dropped the nuisance claim later, and you're going to find out why as we talk about Counterstrike. But basically, they got a judge to say that the spam that came in without authority, it was without authority, was a trespass, and got it blocked. That is currently on appeal. So the question is, as you see, all this stuff again and again and again comes down to what's authorized. We've talked about the spam cases. Microsoft recently has been doing something that a lot of other folks have done as well. I represent Yahoo and Microsoft, Hotmail, Yahoo, AOL, very, very bothered by spam. It's a serious problem in the industry, and they're looking for ways to try and stop this. Here's a little bit of a complaint. Microsoft recently filed a bunch of complaints near where I live in the Bay Area. And what they're doing is they're these so-called John Doe cases where they're suing, and they're saying that these customer email addresses were harvested and that unauthorized, unsolicited commercial email advertisements are being sent to these Hotmail accounts. And the allegation is that that is a violation of the Computer Fraud and Abuse Act, not just trespass, but of this criminal statute. So talk about going after spammers with a vengeance. If I was, as I used to be, a 22-year-old federal prosecutor with no judgment whatsoever and just wanted to have a little bit of fun, I just indict these guys. I just indict the spammers and make a name for myself. So what's permission? Let's talk about some really hard cases. I don't have answers for some of this stuff because, as I say, I think we're slowly coming to the realization that the legal issues and what goes on in technology are really kind of like two ships missing each other in the night. It's going to be a problem. Here are some of the hardest problems, I think, some of the hard problems that we've got. One, of course, is in the P2P context. What's interesting there are a couple of studies have been done with respect to what files are accessible, for example, after you install Kazaa. What is it that the rest of the world gets to see? Remember, you're the guy who installed Kazaa on your system. So whatever you did, presumably I have a right to believe that I'm authorized to see, get, receive, have a peek at anything that I can on your system if I'm using the Kazaa software. Well, with respect to Kazaa, we have about 188 million desktops have been downloaded. It's much more than that at this point. Every client, of course, is a file server. And in this study, which I don't have the site for right here, they said that unintended file sharing is really prevalent. They set up a bunch of dummy files, things that look clearly that had nothing to do with content or music. I mean, these were things like checkbooks and financial information and so on and so forth. And they talked about how when you do drive mapping and you take your laptop back to the company, what you called the H drive before now points to some kind of company directory. I mean, there are a lot of situations where you have a tremendous amount of unintended file sharing going on. So the question, unanswered, is do I have a right to have a look at your financial information if I can get it through Kazaa? System administrators, we've had a couple of cases, very unfortunate cases, in which system administrators, who you think would be the person who could give him or herself authority to do something with that system, have been indicted. And civil action has been taken when they have sort of done a little bit of their own gray hat sort of examination of their own system. They've maybe tested it, they've gone outside, they've kind of done a little bit of penetration, they've sort of seen how things work, how things don't work. They did it without authority from their masters, and that has been held to be something that was not done with authority, something without permission. We've also got, and these are cases in which I've run into personally many, many times where just bad security, this is basically the P2P issue kind of revisited, where just bad security makes it look like authority has been given to the world to have a look at these files. I got a call from a client, a very large software client in the Bay Area, that said, we have this terrible thing. We see these logs here. Our main competitor has come into this area and had a look at all of our source code. I said, whoa, wait a second. How did your source code get there? He said, well, we keep it there because Our folks in India who we're working with, that's where we store stuff. You know, we put it there, they pick it up, they dump it back, and it's just our little lockbox, except it wasn't locked. Somebody made a little bit of a mistake, things happen, you know, things get out of control, and it was wide open to the world. So what can I do now with respect to this competitor? You know what? We had to drop the case. There wasn't much I could do. I couldn't go to the FBI. There was no good civil case. We locked the barn door after the horse had fled. But bad security, which is very, very easy to happen all the time, gives this appearance of permission to the rest of the world. I think the most insidious and most difficult problems we have with respect to permission and when you have permission is in license agreements. And I'll take some responsibility for this since I draft some of these things, and when I'm working for software companies, they're not very nice. But we have real problems where people are apparently agreeing to contractually permit things to happen. You have it, you know, the various adware and spyware and all the sort of privacy intrusions we've had with respect to, you know, all of your behavior being sent back, in effect, to the mothership with respect to your online behavior. And all of that is an access of your system information to somebody else. But apparently you've agreed to it because, you know, you downloaded that thing and you're held to have agreed to whatever those license terms were. Digital rights management is very interesting. There's a lot of really neat stuff that is going to be happening over the next year or two. Microsoft is actually on the forefront of this. But part of what happens is that a lot of these systems get installed on your computer, whether you don't affirmatively like it or not, but you're held to have agreed to the terms of these DRM systems. And part of the system very often is tracking your behavior, tracking your usage, and information going from your computer to a mothership, which otherwise would have been unauthorized, but it's been authorized because of the small print and the licenses that come along with the DRM stuff. UCITA I've talked about. UCITA is that statute that's being circulated around the states, which would allow licensors, and you agreed to it when you opened up that package, allow licensors to turn off the software if they thought that you were in breach. We also have audit provisions. A lot of us sign agreements, not me, you, sign agreements in a lot of different sorts of contexts. It can be a consulting context, it can be a license of software context, just millions of different contexts in which there's some sort of audit provision. We'll read those very, very carefully because a lot of them have a sentence or two in there that it will say something like, and you allow us to come into your system and have a look around, maybe on notice, maybe on no notice, maybe we'll do it remotely, maybe we won't. They're phrased in different sorts of ways. But that would give somebody express permission, if it was phrased the right way, to come into your system and have a little bit of fun. So let's talk about scans, port scans. I had conducted a couple of email conversations with a variety of people in the security industry over the last couple of weeks, just sort of polling them and saying, you know, what do you think? Any problem with port scans and so on and so forth? And, you know, generally everybody thought it was fine, just an ordinary port scan. And in fact, there are some people, the happy hacker, I was talking to her, but there are some people who suggest a reverse port scan as a really good way to sort of let a hacker know that they're there. It's a way of saying, I know who you are, stop it, you know, sending a kind of a shot across the bow. Seems like a perfectly reasonable thing to do. The problem, of course, is that number one, there are some scans where there's non-public data is being accessed sometimes. Now, if you're just banner grabbing, you could say to yourself, well, that's just information that is available for public viewing. So there's nothing wrong with that. It may depend on how the terms of service are at the site. But of course, when you're doing a port scan, you don't go anywhere near a term of service. I mean, that's got nothing to do with what you're doing and who you are and any of this kind of stuff. So you won't be on notice, by and large, of what those terms are. The trouble is, let's look at a port scan from the viewpoint of trespass. You know, is there any argument at all? Is putting aside, you know, a sin flood, putting aside a real sort of sustained attack like that, but just something a little less tricky. Is there any argument at all that CPU resources or memory is being used in any way at all at the target system? I think the answer, and I'm not a technologist, but I think the answer is yes. That's exactly what's happening. And of course, and if you do it a lot, then you start eating up a lot of bandwidth, and if you do it a whole ton, then you eat up so much bandwidth that the system goes down. But think of the first request. That's that second request. That's a trespass. So technically, being hyper-technical here, technically, it's a no-no. There's the last thing I'm going to talk about just briefly before I get onto Counterstrike, which is knowing but keeping silent. It's not really connected to some of the other issues that I'm talking about today, but I just want to throw this out as one more kind of liability that arises in the context of an automated attack. And we'll talk about Slammer briefly in a minute, but imagine something like a worm or something like Slammer. There have been a number of situations in which companies have known of an attack not coming from that company, but they know it's in the works. And Symantec was accused of this, that they knew about Slammer less than a day, maybe 6 or 7 hours before it actually hit. And they didn't tell anybody except for select customers. There have been other situations, of course, in which a manufacturer of software knows of a vulnerability, but does not publicize it. There are a lot of reasons why you might not want to publicize a vulnerability right away, as we all know. But sometimes they're not working on the problem, and they just don't want people to know. So, security through obscurity, that kind of an issue. And, are there legal issues when that happens? And I think there really are. I mean, put aside the policy, put aside your philosophy of how vulnerabilities ought to be handled and how they ought to be talked about and how public it ought to be made and mechanically how you go about doing that. Just put that aside for a second. Can there be legal liability for knowing that there's a bad thing on the way but not telling people about it? And the question is, what is that duty? And I think there is a very good, the question is one of indirect legal liability, liability for somebody else's bad act. Well, the law is full. It is full of great examples of people being liable for somebody else's bad act. It happens all the time. And I think it is something that manufacturers who have customers, licensors who have licensees, people who have a pre-existing contractual relationship with each other, Symantec and its customers, for example, or Microsoft and its customers, or there was a situation, for example, with respect to the Unreal game engine, which has a lot of vulnerabilities in it, and the folks really didn't want that information to get out. And then a company called PivX finally released the information, and the Unreal guys got completely bent out of shape about that, at least for a day or two, until they realized, it really has to be public. But I think there's a real problem of liability there for not informing people that you have some kind of contractual relationship with, that there's something bad coming down the road. So Counterstrike, this is the fun stuff. This is really great. And it is just absolutely interesting. What I'm going to do is, Tim Mullen is going to be presenting at 4. I think that it's going to be a really interesting presentation. He's had this discussion. I'll get into it a little bit more in a second. We've talked. What I'm not going to talk about, though, today is the practicalities of this thing and whether it's smart or not smart to have a counterstrike or attack back. There are a lot of reasons why some people have suggested it is really not smart. It's not a good thing to do. You can make yourself a target for further attacks. You really become a beacon, somebody to whom it would be fun to go after. There are a lot of practicalities. There are a lot of circumstances in which an automated attack just cannot be traced back. Materials have an article that I wrote which gets into some of this stuff a little bit more in detail, has all of the goddamn footnotes that you could ever possibly want, and sources and web links to follow up on some of this stuff. So let's talk about why we care about this. Slammer, Sapphire, this is one crowd that I don't have to belabor some of this stuff. But these things are important because remember who the ultimate audience here is. The audience is a judge. And what I'm trying to do is I am trying to tell the judge that what my client did was okay and it was reasonable. And I need to sort of have some backfill here as to why what apparently looks illegal was something that was reasonable. This is some of the stuff I would talk about. I would talk about the damage, for example, that Slammer did. The B of A, ATMs, air traffic control, and a variety of other things that happened. There's a long list of naughty things that happened as a result of this worm. I would also explain, this is only going to get worse. This is something that the Microsoft folks yesterday told us as well. We all know this. We know that if you're about 8 or 9 years old, you can conduct a lot of these attacks yourselves. And resorting to the law is a bitch. It really doesn't help very much. Bad guys often are not here. I've had cases in which the bad guys were just all over the world, and it just wasn't reasonable to think that I was going to be able to use this legal system or anybody else's legal system to go after those folks. In California, we have a new statute coming into play in July. Any of you who are involved in systems administration should know about this statute because it applies to you, and it doesn't matter where you are. It doesn't matter if your system, the computer, is in California or not. As of July, if you believe that it is possible that an attack on your system compromised personal information, name, address, email, social security number, then you must send out a written notice to those users affected that this may have occurred. It's an anti-identity theft statute. That is, you need to tell me that my data may have been compromised. Maybe it was, maybe it wasn't, but you need to tell me that. So what do I call this? I call this an invitation to sue statute, right? It's like you're going to put a sign on the back of your back, and it's going to say, kick me. And you're going to send that out to all the people who have your, whose personal information you have. And those people being California residents. But of course, California resident information is on computers in Geneva and New York and everything else. So this is part of the background why we care about this stuff. Information warfare issues, again, a lot of fun to talk about, but there's a general consensus that at least in a low-intensity sort of environment, such as we have now, without a formal declaration of war, the legality under the rules of war of what a government does or doesn't do probably gets measured by whether it conforms to federal criminal law or not. And again, we're about to talk about a defense to a criminal indictment. So if under information warfare scenarios, this is sort of interesting there as well. We care about Counterstrike because of the high costs of these attacks. We care because we have exposure to downstream victims. We've got a number of cases in which the downstream victim of, let's say, a worm attack has sued the upstream victim of the same attack because they said, you know, you should have protected us, you should have stopped it, you should have done something. So that's another reason why we care about Counterstrike. Speed of propagation, increasing number of incidents, a lot of the stuff you know. Sapphire was the fastest in history, hit its peak speed in 3 minutes. And within about 10 minutes, almost all of its work was done. Flash worms are much, much faster. There are people in this room who know a lot more about this than I do. But the only point I'm trying to make is that this stuff is fast and the legal system is slow, right? A couple of years, we'll get to you. And expensive. My billing rate is $450 an hour. And after I've worked on your case for a little while, we have bills that we send out on substantial, large cases that are well over $500,000 every month. So it's very expensive to use the legal system. Increasing number of incidences, you all know this, 80,000 last year. So let's talk about some real examples of some Counterstrike. There are a couple of good examples here. A little bit of precedent. Again, very gray area stuff. Nobody knows if this was, how much of this was legal and how much wasn't. The Pentagon in 1998, I think it was, basically forced, they knew in advance that there was a group of people going to be demonstrating and going to be trying to take down some of the systems at the Pentagon. And what they did is they just forced constant reboots at the attacker's browser. They sent bits and pieces of code back. They knew exactly where the stuff was coming from, and they just made it impossible for the attack to continue. And they did it by forcing reboots. In other words, they shut down the entire targeted computer. They didn't stop a process. They didn't just sort of put up a little wall. They didn't mirror a few things back. They shut the computer down. They forced the computer to shut down, which is, when we talk about collateral damage, we'll come back to that a little bit. Connection, ISP web folks providing service to a variety of customers. During the WTO demonstrations, they saw that an attack was coming from a single IP address. And what they did was they just sent all that stuff back. They just put a mirror up, just sent the whole thing back, which was very, very effective. But it was clearly a Counterstrike. I mean, whatever the legalities was of the stuff coming in to that server was just being turned around and sent right back. There was no more or less authorization for either one of those directions. DirecTV did something very neat. And I don't know how to classify this, but it was such a neat little trick that I wanted to talk to you about it briefly. Smart cards so that you can get your TV service, and those cards are counterfeited, and DirecTV would send up updates all the time, and all the hackers, crackers would take the stuff, and they of course would just, whatever updates would come up for the smart cards, they just put into their counterfeit smart cards, and the smart card would continue to work, and so on and so forth. What they didn't know was that there was a program slowly being assembled for all this kind of stuff. DirecTV then sends out the last little update. The last little update gathers up all the modules, glues them together, stitches them, executes them, and burns up the cards. Very, very neat. Very cool. Then, with respect to with code red, some of you know there was a script generated, and I'm not sure if anybody knows who did it, but it basically just went back through the back door that code red had opened, went back and just stopped the process and shut the computer down. A variety of folks were using that. So, what's legal? What's not legal? Spend about 5 or 10 minutes on this, and then we'll have questions. Counterstrike obviously appears illegal. I mean, that's the first order. That's the first take you should have here. That's clearly the default. But I'd like to have a little bit more imagination placed on this issue. It appears illegal because what you're doing is you're connecting, at minimum, you are connecting to a computer without permission. Of course there's no permission. So it seems like you've just violated everything that there is. If the key concept is authority and permission, then you're in violation of all of this federal law and all of this state law, and you can be sued for it. So that's the first order. So the question is there a defense to this stuff? The classic, most of the debate that has been going on this issue has focused on self-defense, classic self-defense. And I don't think that works. Classic self-defense is, somebody's coming at you with a gun, you get to shoot them back. You get to protect your home. You do get to protect your property. It's a fairly broad concept. Of course, it's different in different states and so on and so forth. The real problem with self-defense is you have to put yourself in the mind of pleading this in front of a judge or a jury, and you have to prove that there was no adequate alternative. That's the magic language. No adequate alternative to what you did. And the problem is that in retrospect, there was always alternative. My rule is there was always a patch. You just didn't have it. Why not just build up great defenses? You're going to tell me, says the judge, that you knew where the attacker was coming from, you pinpointed it, you took great care to target a single machine or a single process, but you had no adequate alternative than to shut it down and to strike back? No. If you went that far, couldn't you have just stopped it? So I think it becomes very, very iffy. It becomes very, very difficult to do that. And there was always a patch. Not only just the exaggerated situation we had with Slammer, where the patch had been around for an awfully long time, but there are millions of reasons why things don't get installed. You had technically, you didn't want to take the business down for a while. It interfered with something else you were doing. But self-defense is hard because there's always, in 2020 hindsight, which is the only kind of hindsight we have, there's always going to have been some kind of adequate alternative. So let's go to a new concept called nuisance. Nuisance is cool. Nuisance, again, 800, 900 years old. And the question is whether we can use this. Now, to use nuisance, what you have to do is you have to say, these automated attacks are nuisances. And there's a good argument for that, and it's one of the debates that's going on in various court cases right now. In the Intel case that I mentioned before, it was offered up to the court. The court really didn't address it very well, but there's reasonably good argument. There's at least 1 or 2 cases that say that an uninvited electromagnetic interference with my property, and I'm phrasing it in that really clumsy way because that's how the judge did, can be a nuisance. Traditionally, nuisances are like odors and smells, water's coming onto your property from the neighbor and so on and so forth. And what's really neat about nuisance is that built into the core of the concept is this notion of self-help, which is much, much neater, much broader than self-defense. The thing about self-help is that you can go in on your own without permission and abate or stop the nuisance. Classically, it was, you go in and there's smoke coming in on your property from the other guy's property. You can go in and, put out the fire. You can turn the water off. There's smelly plants. You can uproot the plants. And if you need to break down a door to do it, you can do it. If you need to break a lock, you can do it. If you need to break a fence, you can do it. If you need to smash, destroy, and do things which otherwise would be clearly against the law, you can do it. And you can charge the guy for all of your costs in having abated the nuisance. You can sue the bad guy for all of those costs. So this has got a lot of promise. This theory is something which, if we could convince a court to sort of look at this, might work. And as I say, there are already a number of cases that say that these sorts of attacks could qualify as a nuisance. The real problem is collateral damage. Suppose you make a mistake. Suppose you screw up. The wrong machine, the wrong system. You hit an intermediate system in a distributed denial of service attack. You hit some intermediate systems. You shut them down. You shut down an entire computer, but not instead of just a process. For example, you're not targeted enough. You know, what are the issues here, and how are you going to defend? How are you going to defend when you are sued not by the bad guy, but by some innocent intermediary who you attacked by mistake? And I don't have very good answers to that, except to say that there are a couple of legal doctrines that help. One is that if you shoot, for example, I know I'm going back to self-defense, but we're reaching out for analogies here. If you are defending yourself and you shoot and you miss, you hit somebody else, it's okay. Your intent, your good intent gets transferred, as it were, so that if you miss and you make a mistake in a self-defense context, it is okay. My guess is that if you did something which in retrospect looks like it had a very high risk of collateral damage, and you knew that none of this stuff is going to help you in the long run. If it was incidental, if it didn't do a lot of damage, if it shut a computer down and not just a process, that's probably going to be okay. The likely elements of this so-called abatement defense probably going to be, number one, it was targeted. It was a proportional response. Collateral damage, I don't know. I think we can have some collateral damage and still get away with this. You at your site had terms of service. You had robot exclusion text. You said to the world in a very affirmative, explicit way what's permissible and what's not permissible. That is going to be very, very important, I think. You have to tell people also, if you look at some of the cases, it's probably important to tell the world that if you attack my system, we reserve the right to turn off the attacking process. So this sending out of notice could be important. Rule of decision, I'm not going to talk about. It's too technical and legal, but there are lawyers here who want to chat about whether you can use a state defense to a federal crime. We'll talk about that later. So I just want to finish with just a reprise of the sort of thin gray line issue. What's legal and what's not. We have port scans, which technically probably are not, unless there's some argument you were authorized to do it. There are a lot of ways to get authorization. It doesn't have to be express, but there are a lot of situations in which we do port scans without any kind of authorization at all. Sending search bots, under a lot of cases, just is wrong, even though we do it all the time, and it seems to be harmless. And some cases say it's wrong, even if it's harmless. Accessing files, been available in a P2P context, I don't know. I just don't know. And the targeted automated Counterstrike issue, right now is clearly illegal. There are arguments where it could be legal. I hope you are not version 1 or the test case, but I hope that if you are, you'll give me a buzz. Thanks very much. Are there any questions, any chats? It's about 5 of 10. I don't know what our schedule is, but I'm happy to talk and answer questions and things like that until we get thrown out. Yeah. The question, I'll repeat the question. Let's say you've got a lot of different ports, and the question is, you want to put up your official notice as to what's authorized and what's not authorized. Do you have to put it in one place, or do you put it everywhere? I have no idea what the answer to that is. If it's short, it's something you could put up everywhere. It probably wouldn't kill you. Most people, I don't know of anybody who does that. I mean, people put their terms of service just on websites because that's where human beings are going to go. They're going to read the text on a website. If you've got some sort of banner information that gets returned in response to a port scan, I would put a sentence or two in there. I put the same sentence everywhere. Something like, don't do it, or you can't do this unless you work for, Quest Communications or something like that. A lot of the stuff, the reason I like to talk about this is because this is very gray area stuff. That case it's just never come up. We're just trying to come up with maybe what our best practices here. But if you have kind of a one-line banner, I'd put it in there, something short. Yeah. Yeah, the question is, wouldn't software companies be liable for every bug in the product if they have a if they have a product and they don't talk about what their vulnerabilities are. Yeah, I think it would if they didn't disclose it. I mean, the picture that I was painting was where a company knows of the vulnerability, knows that a risk is being, therefore there's a risk being created of corrupted data or systems going down, and doesn't tell anybody about it. And what's the excuse for that? I can't imagine what the excuse for that is. And if I have a contractual relationship with this company, i.e. I bought their software, that creates the contractual relationship, I think that what they need to do is they need to tell the world about this problem, is what they need to do. Now, there are a lot of problems that occur that are just a function of an interaction between a specific configuration and the software. A lot of companies just don't know about a lot of certain problems. But that's not the question you're asking. You're saying, and you're suggesting by your question, that there's something about the fact that a company knows of an actual problem, doesn't tell anybody. Why should that give them liability? I think it should. The way companies take care of it, I mean, let me just put the finishing tail on that. It's not that, I mean, I think most companies understand that this is an issue. The way they take care of it is they have a license agreement with you. And in the license agreement, which you do not get to negotiate, they say things like, we're not responsible for any of this kind of stuff. They will say, our software could be buggy. A lot of bad things can happen. It's your problem, it's not ours. And there are issues about the enforceability of those sorts of provisions. But the companies are not ignorant of this risk. They try to cover it with a license agreement that would stop a lawsuit. Yeah. Right. Sometimes a bug is a feature. Yeah, you're right. I mean, open Windows, the question was observing, window manufacturers don't have to send out a notice or take care of the problem that the window is something that can be shot through by a bad guy, and a bullet could come through the window. So if you install this window and you take out your wall, you're exposing yourself to further risk. There are a couple of differences, I think. I mean, are there going to be gray areas? Yeah, but there's some really profound differences between the physical window, taking out a wall and putting a window in, and what you're talking about. In the window context, we shouldn't use the word windows because we'll get confused, but in a house context, everybody who builds a house or lives in a house understands this. There's a really common base of information about how bullets work, and bullets can go through glass. And if I really care about it, I mean, everybody in this room knows that if you really care about this, you should get bulletproof glass. We understand that. We're all on the same level of information. It's a very different situation in technology where the manufacturer of the software might be the only person, and I use the word person loosely, but might be the only person who knows of a problem and keeps that information to themselves. The law distinguishes those two kinds of situations very, very clearly, where you have knowledge that other people don't, as opposed to knowledge that you can assume reasonably that everybody does have. Which also means that there are some bugs or problems or features, whatever you want to call them, that are so widely understood or known that just because Joe doesn't know about it doesn't give him any rights against the manufacturer. I mean, if you don't know something that most people in your industry know, then that really is your problem, and the problem sort of goes away at that point. Yeah. About what? The question is, going back to the comment I made, that the mere possession of certain technology is illegal. Does that apply to everybody in this room who's wandering around with some kind of a wireless card? What's illegal is the possession of a counterfeit card, of a counterfeit access device, of a counterfeit, even possession, I suppose, could be in your head. You may just know, in a way that you're not supposed to, somebody else's PGP phrase or something like that. You know that. That is an access device that you now possess in your brain. The mere possession of it is against federal law. Not the possession of your phrase, not the possession of your authorized card. If you're authorized to have it, then all this stuff goes away. But possession of somebody else's device, even if you're not going to use it yourself, even if nobody's going to use it, is a violation of the law. Yes, sir. Right. That's a great question. Yeah, the question I was talking about, that case, I think everybody knows about it, the hot coffee spilled in the lap. And he was pointing out, you know, you have this real-world common sense situation. Coffee spills in the lap. This woman turns around and sues McDonald's. And she got over, the initial award was over $400,000 in that case. And do we expect that kind of craziness to occur in a technology context? I represent McDonald's, and I can tell you what happened in that case. The verdict was reduced down to a much more nominal amount. So the end result of that case, that really was a crazy case. The woman, I should point out, was very badly burned, however. I mean, this just wasn't the kind of hot coffee that spills in my lap all the time. I mean, this woman was quite badly burned. She got some money out of that, which is not, your point though is, everybody knows that coffee is hot. Isn't it something that you need to take care of yourself? The reason it's such a good question is because when you have a legal system that does not understand the technology and does not understand what is commonly understood and what is common and what everybody should or shouldn't know, and does not know really what the rules of the road are, the risk of having a bizarre result in the lawsuit goes up. It goes up very, very high. I cannot tell you how many times I have been sitting around with engineers in a software company, and I've said, we have to explain this to the judge. And these people look at me and say, oh, what do you mean we have to explain this to the judge? This is absurd. Everybody knows you can't do that. It's just that can't be done, or this can be done, whatever. Stuff which is just, it's like breathing air to everybody else. They cannot believe that anybody could legitimately claim that you can't do it or that you can do it. They look at these allegations and these complaints, and they say, this is insane. We're wasting millions of dollars on you to try and explain to a judge that this is crazy or this can't be done. It is absolutely maddening. And that's why that question is good, because it is a very high risk that things that when you have an environment, a technological environment, which is fairly advanced and is not understood by the courts, you will get very bad results. And I think some of these early cases on trespass, reaching back to trespass 900 years ago to talk about what's legit and what's not legit, you send even when there's absolutely no burden on the target system whatsoever, but that's declared illegal, is a really good example of the sort of disjunction that we're seeing now. And it's getting frozen into the law. You know, it could take another couple of years for the pendulum to swim back. Yes, sir. Are there any connections between states suing gun companies on the one hand and taking actions against people who create tools that could be used to exploit vulnerabilities? I don't know. I don't think so. I represented Phil Zimmerman, who wrote PGP for a long time, and we ran into this issue where Phil still gets this, as you know, that having created PGP, he sort of put weapons in the tools of the mafia and everybody else around the world. And there was a time period, I think, where, and we may be getting back to that now a little bit under the new U.S. Patriot Act that's being circulated, where people wanted to look at tools like encryption or something like that and say, well, this could be used by bad guys, therefore you're a bad guy if you create this stuff. Which is, to me, as you can probably guess, is one of the most ludicrous arguments I can imagine. I mean, cars are used to deal death all the time, and car companies have been legitimized. No question has been asked. The reason is that, and the difference between cars on the one hand and the brains of some legislators and encryption, for example, is that they cannot imagine what legitimate uses are of the encryption. They don't understand legitimate uses. If you think that there's only an illegitimate use for a tool, then yes, the odds are going to be very high that somebody's going to come after you. So what's important is for everybody to remember what the legitimate uses of this stuff are. Dan Farmer was at Sun Microsystems when he wrote Satan. And Dan actually was he was at DEF CON 1. He was at a number of the DEF CONs. We sat on a panel together. He had just been fired from Sun. The reason Dan was fired is because he had developed Satan, which was basically a tool that you could use to sort of, scope out a network. He said, look, the reason I built this thing is because, I need to know. what my vulnerabilities are. I need to see how this stuff works. And people were just so bent out of shape that they thought that this is just putting guns in the hands of children and so on and so forth. So what's really important, I think, from a PR and policy angle is that the world has to understand what the legitimate uses of these things are. And once that's clear, you know, the way we beat the encryption thing and the way we sort of handled encryption is we pointed out banks use encryption. You know, hospitals under HIPAA, under this new regulation that's going to be used to have confidential health information, the industry needs encryption. If you start thinking about it for about 4 to 7 seconds, you realize the entire infrastructure of e-commerce needs encryption. I mean, you go to people and say, okay, we'll get rid of SSL. Is that the way you want to live? Is that the kind of life you want to have? And then, you know, it sort of slowly dies down. But that's what you need to do. But it's coming back. You can't stop the vigilance here. The new draft that's being circulated within the Department of Justice, the U.S. Patriot Act Junior, or 2, has sections on encryption in there, and it's coming back that any use of encryption in the conduct of a felony, which means everything, will be a terrorist act and punishable that way. I see Jeff approaching. One more? Okay, one more, and then I'm going to go out there and have coffee. Yeah. Your port. Right. Right. The question is, you need to visit, you need to have some kind of communication with the site before you can figure out whether you're authorized to have a communication with the site. And, you know, that's the place where I think the notion of an implied license kicks in. I think that there are some queries which get sent to sites which the site, because it's available on the internet, because it is in fact connected, should reasonably expect. And I think what the argument there, and this is just a common sense argument, is that there's certain kinds of queries that every single site should expect to get, at least right up front, you know, at that first layer, that actually the first thing that faces the internet. Everybody should expect certain kinds of queries there. And if you can't handle that, then shut yourself off. But that's what you have to expect. And to complain about that kind of a query is just nuts. I mean, I think everybody, that would be an implied license. Yes, come and visit me. You know, you can come up to my front door and knock on the door. I authorize you to do that. Unless, you know, I've put a grid around it or something like that. So I think that's how you would handle that kind of an issue. I mean, there are ways of having things that are extreme, but I think that one would work out. So that's it. I'm happy to chat more. I'm going to do it, though, over coffee just outside. Thanks very much.